Thank you, Azwa. Very happy to be here. I always get excited every time I get invited to speak about this topic because I get to meet so many aspiring entrepreneurs, and obviously, I really hope to get connected with everybody. And happy to have a separate chat if you want to have a more specific discussion about a particular issue. Because I know some people are a bit shy and embarrassed to ask. Maybe it's a very specific question only to that particular person. So happy to do so as well. So very quickly, I am a corporate lawyer. So I've been a lawyer for the last 10 years. So last a year or so, I decided to set up my own law firm to focus only on advising entrepreneurs like yourself, especially technology companies and also investors. So venture capital is also another group of people that we work with. Um, these are some of the companies we work. Obviously, we work with a lot more, but this is some of the companies that we work. We work with fintech company, financial technology companies, accelerators, e-commerce platforms, and um, guys that are in pet industry like Petotum, for example, agriculture, um, social enterprise. So we work with a lot of them in terms of helping them navigate legal challenges that they may have. So, what is the purpose of this presentation today? Because it's also very important. Because obviously I don't know, I can speak for other lawyers, but if you ask a lawyer what is important, I think all lawyers will tell you everything is important, but that may not particularly be a good advice because there are so many things that you may need to know. So we are only looking at these three components today. First is to help you categorize what are the key legal areas that you should know when it comes to setting up your company. Second is helping you to identify potential issues. And the last one is when and why you should care about a particular issue, which means that when you should start looking to find a legal counsel. So, when we speak about disruptive technologies, I'm sure we all have heard this phrase a lot. What does it actually mean from a legal standpoint? The question then you should ask as an entrepreneur is whether or not the business or the idea that you want to do falls within a regulated space. For example, if in a normal scenario, if you want to open a clinic or if you want to open a school, then obviously you need to get the approval from the Ministry of Health and also Ministry of Education. So similarly, if you are a company or a startup, if you are involved in if you look at most of the examples here, they tend to be financial services related, like crowdfunding platform, e-commerce. So they are they are regulated in the sense that there are certain laws that you need to comply before you set it up. So it's good to know once you have your business plan or business model in terms of how you want to generate income, to see whether or not you need to get a particular license for you to be able to get it off the ground. So when it talks about startup, obviously we are talking about technology companies mostly, and obviously some of you may also want to set up a company that may not necessarily be a technology company, but we can cover that as well. But most of the time, a startup is a technology company in the sense that the technology is the key component of what drives the business model. So when we speak about technology companies, there are three things that we should know. Number one is obviously the the technology itself. So, for example, if you are running an e-commerce platform, for example, like Lazada or Shopee, and so many different e-commerce platform now, I'm sure you know them as well. The technology is obviously the online platform that you have, the ability for um, potential buyers to go and sign up for an account, the merchants to be able to get an account and post up their products to be sold on the platform and so on. So that is a technology, to put it very simply. And the second component of what makes a technology company is that the people behind it, because obviously once you have an e-commerce platform running, you need to have a management team who will be the one responding to the emails if there's a merchant that asks a question, if the customer doesn't receive his or her shipment or delivery, what happens then. So the people are the one that will be managing that process. So you need good and stable management team for you to run a technology company. What more if a company is only a startup, which means that it is only started like several months ago? Because obviously, as we all know, 9 out of 10 startups fail within the first year, and then another 50% fail within the first 3 years. So the risk of failure is very high, which is why perhaps the most important component, if I can say so, will be the management team, or the people or the founders that believe in the idea, what they're trying to do. And the last one, obviously not least important as well, is actually capital. Capital is obviously a very interesting topic that a lot of people want to talk about, which is about fundraising. So how do you get money to start your business? So most of the people, entrepreneurs or founders, will start with their own personal savings, or better known as bootstrapping. But after a while, if the business has not generated any income, they need to get the funding from somewhere else. That's where outside fundings like grant, for example, like Cradle Fund, or also investments from third parties like angel investors, venture capital will come to play. So we'll be looking at all these three areas in more detail right after this. But something to keep in mind is that each of these three components is interconnected in the sense that they all form part of what it is to be a technology company. So I don't know whether you guys are already overwhelmed, but please don't feel that this is like a lecture or anything. It's more like a sharing session. So I'm sure you would have a different stage in terms of where you are right now, but look at this discussion more of a just sharing session, so that you know and you have a high level understanding in terms of what are the things that you should know before you start with, or if you already started in your entrepreneurial journey, just so that you can get a level of overview, what are the things that you should be looking at from a legal standpoint. So as we mentioned earlier, we'll be looking at these three components, and hopefully we can summarize it by the next 40 minutes or so that we can have some Q&A. We're very happy to be hearing what are the questions that you may have. So feel free to ask questions in the chat box as well. We can go through them shortly after the end of this discussion. So let's look at the first one, which is the technology. So when it comes to intellectual property, I cannot help but to share this magical device. I'm not sure if you're not an Apple fan there, I'm sorry to know that, but I'm looking at this more of an illustration of what is intellectual property. They are everywhere and anywhere that we see. So Apple iPhone is a good example of an overview. What are the different intellectual property assets that a company may own as well? So obviously Apple is a company, they produce the iPhone, but look at the different types of intellectual property rights that exist. You have the patent, which is the camera that was built that allows you to take good quality images in a low light condition. And you have the trademark, which is the brand name, the logo, and also the name iPhone, so that nobody else can use it except for Apple, of course. And then you've got the industrial design, the way how you hold the iPhone, how it feels, how it was being constructed, that is also protected under the law. And the last one is perhaps the most common, or maybe the usual intellectual property asset that will be important for a technology company would be the copyright. So in Malaysia, copyright is a form of protection for your invention, or as an author. So for example, it covers if you are an artist, you make a lyric or you make a script for a movie, you wrote a book, you write a source code, you are a programmer, that falls within the realm of a copyright. So you can protect your copyright by doing a notification to the regulator, which is the Malaysian Intellectual Property Organization. So I don't want to spend too much time because I'm sure you can look it up as well. But more importantly, just some quick question that you should be asking yourself if you are building a technology company, because we spoke earlier about how important it is to have a clear understanding of technology in a tech company. First is to ask yourself, do you actually own the technology? For example, you may not necessarily have the uh, developer backgrounds, which means that you may need to outsource the platform or the product for the app development to a third party. For example, you engage a software house or software developer to develop it for you. So in that scenario, make sure that the ownership of the software is assigned to you as the owner, because you're the one that is outsourcing it to another party. And the second and the third one, also very important to ask, because obviously if you own a software, you need to make sure that you take steps to protect it. For example, you cannot just leave your source code laying around so that anyone else can go and copy it. For example, you need to go and make sure that the source code is protected. Don't disclose it to other people that may not have access to it. And the last one is obviously very important, which goes back to the first and the second, because you need to be able to demonstrate to customers that you actually own the intellectual property. If you don't actually own it, you cannot make money from it. And that's very important, because what is a technology if you cannot exploit it? And that's why intellectual property is so important. And you have companies that have very little physical assets, but they have a lot of intangible assets in terms of the software that they have. As you all know, most of the software now are stored in cloud. They may not necessarily be the normal software that we buy those days. So now that we're done with the intellectual property, because I think I want to spend a bit more time on people and also fundraising, because I think that's also a crucial component that I'm sure many of you are finding ways to navigate very quickly. Most of the time, when you set up a company, you may have another person as a co-founder. So usually, it's a two persons kind of role. So somebody will be doing the CEO, somebody may be the marketing person, and so on. So one of the things that we realize is that most of the time founders use trust, or what people say the gentleman's agreement a lot. So there's no agreement in writing. That may not be a wrong thing per se, but it can be risky in this if the event that there is a dispute between you and your co-founder. And obviously we cannot anticipate or predict what will happen in the next 6 months, 12 months or so, but it's good to formalize it in writing, just so that you can fall back in the event that there is a misunderstanding. I think one of the things that why we always encourage founders to put their agreement in writing is because startup is very challenging, and sometimes one person might just decide to leave the company after some time, like after 6 months, 12 months. Then what happens to the shares that has already been issued in terms of the ownership? So as you being the remaining founder, you may want to take over the shares so that you can find somebody else to take over the co-founder's role, for example. Some of the things that we also realize is that it's very tempting to just do a straight uh, split the equities. For example, if there are two founders, you just do a 50-50 split, or if there are four founders, you just do a four-way split, like everybody gets 25%. It's very easy to do that way, but you should check carefully whether or not in actual fact would everybody puts in the same amount of value in terms of work. If that is not the case, then obviously that will be bound to create some disagreement. So have that difficult discussion up front. Don't wait for too long, because you don't want to have an internal dispute at some stage when you already spend so much time and effort in growing the business. So have that difficult discussion now, so that everybody is clear in terms of what they can contribute and what exactly that they should receive as part of their compensation in return for their time and effort into the business. So the last 2 points is also very common. A lot of founders like to promise that they want to give shares to their co-founder or their early management team, but sometimes they take too long to do that. Please don't do this, because first, you're also causing a bit an uneasiness, because maybe um, you have made a promise that you're going to give the equity. You should at least put it in writing, so that the person that you promised will have some understanding of when the shares will be issued, so that there will be no misunderstanding in the future. So very quickly, I know this slide looks like there are a lot of words inside it, but there are only 3 things that are important when it comes to managing a team. So I don't know whether maybe some of you have already hired someone full-time, for example. Generally speaking, there are 2 types of engagement. You can engage someone either as a full-time worker or employee, which is quite standard. I mean, everybody that had been an employee before would know what an employee means. It comes with a set of statutory obligations. So obviously, in this scenario, if you start a business, then you will become an employer. So under the law, as an employer, you are responsible to make sure that all the necessary payments as an employer is done. For example, the Employee Providence Fund, the Social Security, and now the EIS, the Employment Insurance Scheme, and also income tax deduction if the salary of the employee achieves a certain threshold. I think it's 3,000 ringgit or something like that. So the point that we're trying to make is there is no exception or special exemption for startup. Everybody is treated the same way. So you cannot run away from paying this statutory obligation if you are a company. So what will be interesting is that if you look at the slide down there on compensating your team, is that maybe perhaps because you're only starting a company, you may not have the financial resources to pay the staff full time. You may want to offer a combination of the payment in both monthly salary, but also in equity in terms of ownership in the company. That is also very interesting in the sense that you're offering an opportunity for the staff to also be involved in the company and also become part owner in the business as well. And that is also very unlikely to happen in more bigger company. For example, I mean, if you join Google or Microsoft today, you may not necessarily get this offer. Obviously, they still have employee shares option scheme, but you have to stay a bit longer, and the value of the equity may not be as high as what you may get if you join a company at the very early stage, for example. The last point that we would want to make this slide is that everybody that is involved in the company needs to sign this document called a confidentiality and assignment agreement. So what it means is that we spoke earlier about intellectual property. So what it means is that everybody that is involved in the business or the company, needs to make sure that they do not go and share confidential information about your business to another person. And how do we make sure that they don't do that? Obviously is to get them to agree in a document, so that in the event that such thing happens, you can consider taking legal action against the employee or the person that has agreed to it in the first place. So very quickly, what are the three usual definition of the people that you may have in your company? Number one, we all know this very well, which is an employee, which is usually a full time. It comes with the employer's obligation, EPF, SOCSO, and the usual um, payment of salary, and the employment law will apply, which is very different from the second and the third column. The second column is independent contractor, or better known as freelancer. So as you know, Food Panda riders, Grab food riders, they are usually known as freelance or gig workers. They would fall within the second column here. They are very short term or assignment basis. So if you hire someone as a web designer for your company website, that person would fall within this definition. So in that scenario, you only pay the person the fee or the scope of the payment, but there is no other obligation to pay for the employment benefits and so on. The last one that I want to quickly touch on is actually on the interns, because I know a lot of you are considering to get interns on board, because either they are cheap or you have to pay them so much compared to a full-time worker, or you may just do an unpaid internship. That is not necessarily a wrong thing, so long as you make sure that you teach them something valuable and worthwhile. But just be careful, because under the law, interns are not really defined. There's no definition of what is an intern under the employment law. So because of that, um, there might be a potential risk that if you tell the intern that the intern needs to come to work from 9 to 6 and ask the intern to do things like that, there may be a presumption that the intern is actually an employee, and because of that, you may need to pay the usual statutory obligation. So that's something that you need to be very careful when it comes to drafting the appointment letter for the intern, or also the freelance, and also the employment contract, because they have different legal implications when you decide to have them as a part of the team member. So we spoke about this earlier. We come across this a lot in our work. Uh, some companies would misclassify employees as freelancers, and freelancers are wrongly defined as employee. So for example, we spoke about this earlier. Um, a lot of startups wants to save money. They don't want to pay so much on full-time employees, so they would classify people as interns. Please be careful when you do this, because EPF, for example, has a very strict enforcement laws. They have the power to go to your office and premise and actually do an inspection. So if they found you and you get caught for doing this, you'll be penalized, and you have to pay for that EPF. And so please look into this very carefully, because as an employer, you have very strict duties that you need to comply under the employment law. Um, I just want to cover this because this is a bit like a often topic, but I think it's also important that we have a quick discussion about working with service providers or advisors. I'm talking about people like myself as a law firm or as legal counsel, company secretary, accountant. So if you are setting up a company, you will need to engage a company secretary to help you set up a company. So if that when that happens, please make sure that you run through this checklist. Happy to share the slide. Just drop me a note on WhatsApp. I'll pass you my number at the end of the discussion, and my email. Just drop me a note and we'll send you the deck. You can run through this um, checklist. The first thing is to ask the person whether or not the person has worked with a startup before, because this is also very important. You want to work with someone that has experience working with an early stage company, because the challenges that you will have as an entrepreneur is very different compared to someone that runs a normal brick and mortar construction business in terms of navigating issues like fundraising, for example. Um, Sometimes it doesn't happen very often, but there are a lot of entrepreneurs that have too many advisors, so there are too many cooks in the kitchen. So sometimes they get too many advice from so many different people, and then they cannot decide what they want to do. So think carefully. In the end, as an entrepreneur, you need to make a decision as to what is the best for you at the particular time when you make that decision. So that's also important. Um, I think most law firms, most accountants now have a startup friendly packages. So you should ask them if they can give you that pricing. What is important is that it helps you manage your cash flow so that you know exactly how much you pay if you decide to engage them. One good thing that I want to share is also that most law firms or most accountants in Malaysia do not charge for consultation fee when you meet them for the first time. So please don't hesitate to go and arrange a meeting, because you can ask all the questions that you want, and in the end choose a good company secretary that really understands your business. And also the more question to ask is, do you actually like the person that you want to work with? Because once you engage someone as a company secretary, you will be working with them and for a long run. So you don't want to be changing company secretary very often, because there's also cost involved, and it also can be quite messy in that sense. So just very quickly to cover on some tips about managing relationship with service providers. Okay, so we gotta go to a more technical stuff now, which is some of the key points to look at when it comes to looking at contract negotiation. There's several things to look at here. I may not be able to go to detail because of time constraint, but the four main things that basically there are a lot more important things. But when it comes to a business, perhaps there are only four main things that why a contract is important. One is obviously is to define your intellectual property rights. We spoke about this earlier. As a technology company, your technology is essentially everything. So when you sign a document with a customer or a client or a vendor, you need to define clearly what kind of intellectual property that is being the licensed. For example, you're giving someone the uh, uh, option to use your intellectual property, the right to use your IP. Um, I think right now we're all talking about data. What is data? Data is the new oil. So obviously, the question then will be, under that contract, which party will own the data? So for example, if you are an e-commerce platform, you're working with a merchant. So the merchant is the one that submits the document about the customer. So would you be able to record and take the ownership of the data of the customer? So that's also something else for you to consider in the contract. The second one, obviously, why you should have a contract is because it helps you define expectation, so that nobody would be able to come back and tell you, oh, you promised to do this and that, because you have this in writing, so there cannot be any dispute at all about that anymore. So that's why we have things in writing. The other two are also very important. Is actually, number one is to be able to limit your liability when it comes to any potential legal action. Contracts do allow you to limit your exposure in terms of how much that you need to pay in the event that there is a legal suit. And the last one, also very important, and that's why they always say that also a good lawyer is a lawyer that knows how to get the client get out from a bad contract, or a contract for that matter, is to look at the termination clause. So what happens if the relationship doesn't do so well or doesn't work out the way how you want them to be? The termination clause is important. It helps you set out clearly at what point you can exit a contract. So these are the reasons why we should have a contract in place, because it helps manage your risks and also your liabilities as a business owner in a company. We are looking at the last section now, which is also very exciting topic on fundraising, which is capital. First, very important, a lot of entrepreneurs ask this question like, when should I set up a company? Um, when should I spend the money and pay the company secretary? The answer is as soon as possible. And if you are really serious about running a business, if you're not serious about running a business, then please don't go and set up a company. Obviously, you'll be doing a lot of favor to the company secretary, and they will earn some fees, but there's also a cost of running a business. You have to pay for the annual audit and the annual filing fees to the company's commission. Um, so these are the two questions that you should ask. First, are you really serious about running this as a business? If you're seriously passionate or very obsessed about running a business, then yes, you should set up your company as soon as possible. Why it's important to set up a company? Obviously, you want to limit your personal liability. If there is one important point that I can highlight from this particular slide, that is the second point. So right now, I know many people would start with a normal enterprise or sole proprietor, which costs like 50 or 60 ringgit. It's very cheap. The challenge with that kind of setup is that every time you sign a contract or you sign a document, you are signing it under personal name. So what it means is that if something goes wrong and the customer decides to sue you, for example, and it goes to the court, and if you end up being the one that is liable or wrong, the 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 claimant or the customer can go after your personal assets or your house, your personal savings, and so on. And that is why people set up a company. They don't set up a enterprise simply because you want to be able to separate your personal assets and liabilities against the company. And that's why people have a company in the first place. So another reason that you have a company is obviously to be able to do fundraising, to have your own separate accounting so that you don't use your personal bank account to receive money and so on. Um, and most of the time, 9 or 10 out of 10 time, the plain vanilla structure in Malaysia is a private limited company or Sedang Berhad. Please don't go and set up a different structure than this, like limited liability partnership, for example. It may work, but it doesn't work in the long run in the sense that if you want to do fundraising, for example, you still need to change or set up a new company as Sedang Berhad. Then also can be quite costly and time consuming. Some of the things that obviously boils down back to getting a good company secretary. If you have a good company secretary, most of the time they will sort out your company records and everything. So you don't need to worry much about that. And some of you, I do not know how are you considering to set up a company somewhere else already. If you decide to set up a company in other places outside Malaysia, then obviously you need to get advice from a local legal counsel over there so that you know exactly what you're getting yourself into, because different country will have a different laws when it comes to setting up a company there. So what are the important things to look at when it comes to fundraising? The three things. Number one is preparing for fundraising itself. I don't want to spend too much time on this because I'm sure you can find a lot of resources on the internet about how much money you should raise, what is the valuation that you should set for the business, um, what is a term sheet, for example. Essentially, it's a precursor to the whole process. The term sheet is a simple summary of what the commercial terms for an investment in the business. And then what happens next is to, um, depending on how sophisticated your investor might be. For example, if you are dealing with a financial investor like venture capital, for example, they would engage law firms like us to do a legal due diligence which is like a form of audit. So we will come in and look at your company's business, whether they are healthy in the sense that we'll ask for all the records and the documents, to look at your contracts, to look at your filings, to make sure that they are up to date and in order and they are all done correctly and nothing is missing. And the last one, obviously, you need to sign the document. So the whole process can take anywhere between 3 to 6 months. 3 months tend to be the fastest, because there are a lot of process involved. But again, it all boils down to the investor that you are working with. If it's a normal angel investor or families and friends, and probably you may not need to go through this lengthy process. But again, this is a standard process that takes place when it comes to a fundraising, for example. So even when you raise money from, for example, Cradle Fund, which is a government agency that disburses funding for 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 startup in Malaysia, you still need to go through the same process. You need to go for your pitching, and the investment committee will decide whether or not to invest, and then they'll appoint a law firm to do a audit. And then in the end, if they are satisfied with the um, report about your company, then they will ask you to sign the investment documents for you to receive the funding. What are some of the issues that we come across a lot as a legal counsel is that um, which may not necessarily be legally related, is obviously some of entrepreneurs have very poor business plan, and obviously we're not expecting 100 pages business plan. Most of the time it's only a simple 8 to 10 slides about what the company is about and what the company is trying to achieve. And the second and third one are not related, but the second one is the part of, as an entrepreneur. I know some of you may find all this financial structure or terminology is very overwhelming, but as an entrepreneur, you should know at least what are the differences between things like what is a pre-money valuation, what is a post-money valuation, capitalization. So these are some of the key phrases that you should know. So especially if you are an entrepreneur, you should know how to read an audited account, a balance sheet, or financial statement, so that you will know exactly what you're talking about when you speak to an investor, for example, because these are the things that most investors would want to know in terms of your financial health of your business. The third and the fourth one are quite related. It's just about obviously when you're starting a business, the temptation will be very high to take money from everybody that offers you money. But please consider carefully the person that you want to have as an investor, whether or not the money come from legitimate sources, for example. But more importantly, to know and ask yourself, like sometimes an investor may put only a small amount, let's say 100,000 ringgit, but not a large amount, like, compared to another person that puts in 500,000 ringgit but does nothing to the business. But a person that puts in a smaller amount, like 100,000 ringgit, could help you open doors to share your potential customers or new partnership, for example. So sometimes it's not just the investment amount in monetary ringgit as only, but also the potential connection or the expertise or the network that the investor can help you offer once the investor comes as a investor shareholder in your company. And some of you may want to use Finder or broker to help you look for investment. That is not necessarily a wrong thing, but please make sure that you are clear in terms of who will be responsible to pay for the compensation. Most of the time, the company is the one that needs to pay, but the challenge then will be the investor may not like it, the fact that a percentage of their investment money will be used to pay off a broker, for example. So this is something that you need to be very careful about if you want to use a broker. The last one obviously ties back to what we disclosed earlier, we spoke earlier, which is about disclosure. You need to make sure that every time you issue shares, the whole paperwork is done correctly. And obviously, because you're a private company, you cannot do a public fundraising. Like you cannot do a huge signboard to say that you are fundraising and so on. It needs to be done in a closed manner. So very quickly, these are some of the contracts. I'm not going to go through that in detail, but these are the usual financing document that you need to sign if you're receiving an equity investment. Drop me a note on WhatsApp or email. I'll be happy to share you the link for the Google Slides to get a copy of the deck. So let's look at some quick case study before we go to the Q&A. I, I'm not going to tell you the company name. I'm just going to quickly run through the facts of the story of what actually happened, because this actually happened based on a true story. A large unicorn company reached out to you to partner up to work on developing a new technology for speech recognition for a smart TV. So you are a AI tech startup. So you've got the technology, and this big billion company comes to you and wants to partner up. But during that 3 months, after you said okay, you never sign any agreement. But one day before the launch, suddenly the big company sent you an agreement for you to sign. And this was literally before you and your partner did the press conference the day after that. So you said no because you said you need some time to think about it, but the big company didn't care about what you said at all. And the next day, they went and launched that smart TV without you being mentioned at all. And guess what? This actually happened to a company, and it's actually Xiaomi. So, so you can look it up. Just type this Xiaomi smart TV dispute, and you can read a lot about it in terms of what actually happened. So the point I'm trying to make here is what we spoke earlier about why it is so important to have things in writing so that you don't end up in this kind of dispute. And obviously, it looks very embarrassing that this has to go out in the public and so on, and obviously affects your reputation at all. Um, let's look at the second case study. Also very interesting. I'm not sure whether you can guess which company I'm referring to. You and another two co-founder decided to set up a social media platform, and then because you're serious about doing this, all three of you set up a company. But 1 year later, it looks like out of the three, only you are really serious about doing it as a business. The other two guys decided to do something else and took a different career path. But what happened was that because you didn't really have anything in writing, you never actually get the two guys to transfer the shares back to you. So to cut the complexity, you decided to go and set up a new company all together and start fundraising with a new company instead of using the first company that you set up, and then you took over the company instead. So this actually talks about this. I'm sure, I don't know whether you watched this movie. If you haven't, I really think you should watch it because it talks exactly about why it's important to have a very upfront discussion with your co-founders, because you're starting a startup and there are a lot of challenges involved. So people may lose interest, or they may got another offer somewhere else. So it's very challenging for you already if you're really serious about doing this business. So go and watch it. Very interesting movie, Social Network. Last point that I want to make is, I know maybe you'll be asking like, why should I care about all these legal issues because I'm only a startup? I mean, the answer for that is also very straightforward. The fine or the cost of not doing it right will probably be a lot more. You may even lose your company if you don't comply with the laws. And one of the reasons why it's important for you to take note of the legal issues, obviously, is because most of the time, if somebody wants to invest in your company, they engage law firm like us to do the legal audit, and that's where we'll find out all the funny things that have not been done correctly, and it's going to be very embarrassing, and you may also lose out leverage. So if you say that your company is worth this much, you may make the company value goes down, or the more issues you have, the more business leverage that you may give away during the negotiation. So very quickly, some quick advice. Anybody that contributes to the company needs to sign an NDA and assignment agreement. If you hire someone full time, you cannot run away from paying the statutory obligations. The third one is every time you issue shares in the company, you need to get the company secretary to do the lodgement so that everything is recorded, and that's why you need to get a good company secretary. So any change of equity, if you want to transfer the share to somebody else, or if you want to do a shares option to your staff, make sure that you do all the usual paperwork so that the company secretary will need to do all these things. Some other quick advice before we end and get your Q&A. We need to look at understand the key terms to look out for when it comes to contract. If you want to outsource, get a good legal counsel to help you, especially um, on the important terms. If you want to use a template, make sure that the template follows Malaysian laws. And please go and get a legal advice as soon as you can before you start your fundraising. And there's so many good lawyers out there, and I'm sure you can ask for a referral in terms of who you can speak to that can help you with your legal matters. So thank you very much for listening. Happy to answer your Q&A now.
All right. Thank you so much, Izwan. Is there anyone who wants to ask any question to Izwan?
Hi, I'm Alex from Darmadia. I have some questions to ask you, Izwan, three in fact. So I'll just get right to it. So my first question is, with regard to registering code as an IP asset, what happens if a significant portion of the code uses like open source libraries? How can we register that as our asset if we are using a lot of open source code in it? So that's the first question. Second question is, so what do we need to do to make sure that any contracts we draft and sign are legally enforceable? So do we need to do things like stamping the agreement and whatnot? For the third question, I've seen like many contracts, especially if you're like a young company, they often have a clause where it requires the personal guarantee of the company directors. So wouldn't that negate the benefit of having a Sdn Bhd to limit our liability? Yeah, those are my questions.
Hi, Alex. Thank you for your question. Number one, the fact that you're using open source of most of the source code came from public domain in terms of they are open source, so there's no reason why you should be worried about getting it registered. The only challenge is if you use third party and you need to get the appropriate license, that could be a challenge because there could be a claim of infringement there. So long as you're using open source um, 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 stack to come up with your source code, there shouldn't be an issue for you to do the notification. That's number one. Number two is on the online contracts. There's no issue for you. The fact that you don't sign, the fact that you don't stamp a contract does not make the contract invalid. The contract is still valid and enforceable. The only challenge is that there is a dispute in the contract. If you want to bring the document to the court, you need to pay a bit of penalty for the stamp duty. That's the only challenge. And obviously now you don't need to get the physical signature anymore. You can do online signature like DocuSign or EverSign, or things that's also valid. The only thing that you cannot do is certain documents like land transfer and other statutory document that still needs to use the normal physical signature. And the last one about personal guarantee, yes, it is very challenging. Banks still ask directors to sign personal guarantee. So obviously you can negotiate, but most of the time you cannot negotiate. So that's obviously a challenge. But most of the time, you shouldn't be any issue for you to sign a document under the company. The only guys that always ask for personal guarantee has always been the bank. So which is very hard to negotiate with the bank, because especially when you need the money. So I hope that answers your question. Number one, no issue at all for you to file your copyright registration with the regulator, because even if you use third-party sources, also you can still file the notification. It's just that if there is a dispute, then you need to demonstrate that you actually own it, and that's the part where it gets a bit challenging.
Okay, thank you, Izwan.
All right. We have a question on the chat room.
Yeah, Yang Rong asked a question. If you hire someone on a short time, part time, for 1 or 2 weeks, most of the time you don't need to pay them EPF. So if there's no intention for them to be an employee, so if it's just for 1 or 2 weeks, then there shouldn't be any EPF also payment. But again, if you tell them every 1 or 2 weeks, every month they have to come and work, then obviously it looks like it's a part-time employment. So that's the part where you need to look at the document very carefully to say that this is actually a commission-based kind of thing. So it's not really a salary, it's more like a commission or allowance kind of payment.
All right. Okay. Any other question, ladies and gentlemen?
Yeah, I have one question. Morning. Assalamualaikum to Mr. Izwan. I'm Ms. Novita Adriani, Secretary for Youth Entrepreneur for Tube Penyalang. Okay, I have 3 questions. One, if let's say the youth entrepreneur didn't have any knowledge regarding share partners or contractual agreement, if the youth entrepreneur make agreement, but they didn't have any black and white regarding those, how they want to sue the other persons that have the agreement after they sign all the documents, and they might be have lost all the capital because of the share partners or the contract. Okay, the second one, just now I saw the slide regarding the self-appropriate company spelling. You mentioning about failing to appropriately limit personal liability. Do you have any advice regarding those? To have like a long-term entrepreneurship. Okay, the third one, this is one question regarding the payment for events. Okay, how we want to do if let's say we give the payment from the company to the person or personnel, but we have the documentation like receipt or invoices from them. Do you have any advice regarding those, Mr. Izwan? Thank you. That's all from me.
Okay, thank you, Novita, for your question. Number one, on the partnership dispute or partnership agreement, obviously we need to look at the agreement that you mentioned. I mean, obviously, if there was a partnership agreement, then all the parties to the partnership should have signed the document together so that it means that everybody has agreed to the terms. So if there is a partnership dispute, then obviously we need to look at what is the actual dispute, if there is a possible way for the parties to be able to negotiate or have someone to mediate. So I do not know whether you could be a mediator to help the negotiation process to achieve a settlement, failing which, if that is not possible, then you need to advise your partner to consider taking a legal action. But again, you need to speak to a lawyer to see whether or not there are enough documentary evidence in terms of whether or not you will be able to be successful in the claim in the court, because in the end, it all boils down to which side has a more convincing claim or argument. Like, do you have the paperwork, or do you have the WhatsApp messages, the screenshot, or the discussion in place? Because the judge does not have information about what happened. He or she, as a judge, is only making a decision based on what you have, which is why it's so important to have things in writing. So number two, when it comes to company, obviously, you should set up a company which is a private limited company, because you want to be able to protect yourself from any legal liabilities that may be attached to you if you are signing it under personal capacity, which is why we always tell company entrepreneurs to set up a company as soon as possible, so that every time they sign the purchase order or invoice, they're signing it under company instead. And that is something important that you should do as soon as possible if you are still operating as a sole proprietor or enterprise. Number three, when it comes to payment, obviously it all looks at, again, is a very specific question relating to your scenario. It sounds like it's more of a payment collection issue. So you may want to check with a local lawyer in your area to see whether or not there is a strong ground for you to be able to claim for the payment, because it sounds like the payment was meant to be made to a company, but instead it was made to a individual instead. So what would be the likelihood of you recovering the amount? So I know it's not very useful answer for now, but the thing that you can do very immediately is to sit down and write a chronology in terms of what actually happened from the first interaction that you have with the person and the company, and really um, when you bring that document to the lawyer, at least the lawyer will know what actually happened, so that they can advise you in terms of what are the likelihood of you succeeding in the claim. So sorry, this is not a very helpful advice, but it sounds very contentious. So I don't know whether Azwar would know a local lawyer that can help Novita in this particular instance.
All right. Okay. We'll take one last question because I think we do not want to take too much of Izwan's time. From Ain and Zeta, I think it's Nora Zeta. P2P lending, funding, which one is good funding for community business-based business?
Yeah, thank you, Ain. Thank you, Zeta. Very happy to answer this question. P2P and equity crowdfunding, obviously, they are both regulated in Malaysia by the Securities Commission. So they both have different characteristics, although they both serve the same function, which is to fund your business operation. So one is you are borrowing money from the investors. Second is you are actually selling your company's shares to the investors. So when it comes to community-based business, again, not very clear what community-based business you are running, but again, it all boils down to the commercial consideration. So if you're borrowing money, you need to pay back the loan amount because you're borrowing the money. So for example, if you borrow 100,000 ringgit from P2P lending, there's an interest rate that you need to pay 5%, 6%, or 7%, depending on how much interest that is applicable based on the risk involved. So that is different from equity crowdfunding, where I believe in your business. I think your business can grow. I decide to invest 100,000 ringgit. Let's grow together. And if things work out, it will work out. So it's very different when it comes to the characteristic of the investor as well. So an investor that invests in a P2P lending, for example, is expecting immediate return of the investment. So once I lend you 100,000 ringgit today, in the next 3 months or 6 months, 9 months, I expect you to pay me back my interest plus the capital that I have given you. And that is very different compared to equity crowdfunding, where I invested 100,000 ringgit to you today. I may or may not get my money back. I may get my money back, or the company may grow bigger in the next 3 months, 3 years, for example. My 100,000 ringgit could then be worth 3 million for that matter. So again, sit down and really understand all these crowdfunding platforms have very good resources and infographics. So I'm sure you'll be able to decide which one that will be best suited for your current commercial needs right now. So thank you for that question, Aina and Zeta.